A writ of mandam... A writ of mandam...
A writ of mandamus.
What's that?
Do you want to know?
I'm not sure.
It sounds more complicated than it really is. And once you find out what it means, maybe it's something you can say to impress your friends.
How you doing? Oh, me? Fine. I just got to get rid of mandamus. Like that?
Not exactly. Maybe I should tell you the story.
Maybe.
Marbury versus Madison, one of the most famous cases in legal history.
How come?
Well, mainly because it established the principle of judicial review.
Again with the big words. What's judicial?
Judicial review. It means that the Supreme Court can limit the power of the President of the United States and Congress by declaring legislation unconstitutional.
What? I don't get it.
Let me explain. You know how there are 3 branches of government?
I do now.
Judicial, the legislative, and the executive branch. The judicial branch is run by the Supreme Court, while the legislative branch is run by Congress, and the President of the United States heads the executive branch. Judicial review says that when Congress makes a law or the President takes action on something, the Supreme Court or the judicial branch has the power to review the law or action and determine whether it's in harmony with the United States Constitution or not.
Okay, I see. And if the law or action is not correct?
Well, if it's not correct, the Supreme Court can declare it unconstitutional, which means the Congress or the President has to go back to the drawing board and fix that law or action.
Makes sense to me.
Good.
I'm guessing there's a story here that caused them to establish judicial
review. Yes, there is. Would you like to hear it?
Yes, I would.
Well, it all started in the year 1803. President John Adams had just lost his re-election campaign to Thomas Jefferson, who was about to become the 3rd president of the United States. But Adams, who was a member of the Federalist Party, wanted to help his political party to maintain as much control as possible over the judicial branch. So, on his last day in office, he named 42 new justices of the peace and 16 new circuit court judges who were all Federalists.
As opposed to what?
As opposed to Democratic Republicans, the party led by President-to-be Thomas Jefferson.
I see. Clever.
Each of these commissions or letters was carefully signed by President Adams and sealed by the Secretary of State, John Marshall. Now, remember that name.
John Marshall. Got it.
Marshall had been given the task of delivering all of these commissions in one day to the people who were named to these new positions, a task that turned out to be too much for one man to handle. The next day, when Thomas Jefferson became President of the United States, he ordered the new Secretary of State, James Madison, not to deliver the remaining commissions. He said they were void because they were not delivered while Adams was still president. William Marbury, who was appointed as Justice of the Peace by President Adams, then filed a petition asking the Supreme Court directly to grant a writ of mandamus.
What's that again?
A writ of mandamus is an order from a higher court given to a lower court or someone in authority which obliges them under the law to do or not do something specific.
Kind of like a quick fix when there isn't enough time to discuss the details?
Yeah, basically.
I like that. Getting things done. Taking control of the situation.
May I continue?
You may.
Thank you. So, William Marbury asked the Supreme Court to issue a writ of mandamus, compelling the new Secretary of State to deliver the commissions.
Who is Marbury again?
Well, Marbury was a man who was appointed by President Adams to be a Justice of the Peace. However, since Marbury was one of those people who didn't receive their commission before Adams left office, he technically wasn't the Justice of the Peace yet.
Then who was Madison?
James Madison was the new Secretary of State, who was told by the new president not to deliver the commission.
To Marbury?
Yes, and others.
Gotcha. So, Marbury versus Madison. Game on. And who's the judge?
Well, that's another interesting aspect of this case. The judge was John Marshall. Remember that name?
Yes, but I thought he was the former Secretary of State under Adams who sealed all of the commissions and delivered most of them.
Well, he was, but before leaving office, President Adams cleverly appointed him to be the Chief Justice of the Supreme Court.
Wow, smart man. So what happened?
Well, not surprisingly, the court decided that Marbury was entitled to the commission. However, the court also decided that the Constitution did not give the Supreme Court the right to issue the writ of mandamus.
Why not?
Well, because Section 13 of the Judiciary Act of 1789, which granted the right to do so, was invalid because it did not follow the constitutional restraints. Now, here's another key phrase. Are you still paying attention?
Yes, I am, but my head is spinning a little bit.
Oh, well, I understand. Original jurisdiction, which is the power to bring cases directly to the Supreme Court on matters dealing with the Constitution, only applies to cases affecting ambassadors, other public ministers and consuls, and to cases in which the state shall be party. By extending the court's original jurisdiction to include cases like Marbury's, Congress had exceeded its authority.
And so...
Marbury was denied his commission.
So he didn't get to be the justice of the peace?
Nope, he didn't.
Interesting. But that's it. The guy didn't get the job?
Well, there were more important implications as a result of this case.
Oh, like establishing judicial review, right?
Exactly! This was the first case to establish the principle that when an act of Congress is in conflict with the Constitution, it is the obligation of the court to uphold the Constitution.
Judicial review!
And throughout its long history, when the Supreme Court has needed to affirm its legitimacy, it has cited Judge Marshall's opinion, establishing the judiciary as an equal branch of government.
Equal in power to Congress and the President.
You are one smart gavel.
Why, thank you, Professor. You're pretty smart, too.
Now, what area of the law would you like to learn more about next?